Hey guys, so it is day 2. We're going to try this again. Let's see. So things we're going to do today. We are going to go over my website, make sure you know where everything is, talk about what's on Google Classroom. I'm going to tell you guys to watch some specific videos on my on the website. And then we're going to do the PowerPoint lecture. Shouldn't take very long, probably about as long as it did the other day. I was going to show all the videos on here with you guys, but then I thought that was kind of weird. So I'm going to suggest that you watch some specific ones that are on my website. Okay, so next week, I do not know exactly what day, but next week I am planning on doing a live Zoom meeting, which this is the program that I'm using. It's called zoom.com. I'll post on Instagram and on Remind so you guys know when to log in. I'll send a join code through Google Classroom, and then we'll have a live meeting, and it'll look kind of like this ridiculousness that's on the screen right now. So I'll post that once it's finished. I'll convert it, and then I'll put it on Google Classroom so you guys can go back to it if there's anything that we talked about that you guys are like, we need to go back and check and review and stuff like that. Topics are going to be Federalist 78, multiple choice questions, and possibly some FRQs from the chapter. So you know how you guys, with the reading guide, you guys would usually go to the end of the chapter and do the multiple choice questions. Well, I'm thinking that we should go through those and possibly talk them out. I don't know if that's going to help or not, but I think it's a good idea to try. Okay. All right. So on my website, here's where we're going to be. Same place as last time. Unit 3.4 institutions, judiciary. Make sure you know the website, apgopo2020.weebly.com. Hover over units, and then go down to where we are with it, which is institutions, judiciary. We'll scroll down to day 2, which is the Supreme Court. We're still dealing with the court system. Last time we went over what the courts were, types of law, sources of law. We went over criminal law, we went over civil law, we went over criminal court cases, civil court cases, and things like that. This time we're going to stick directly to these Supreme Court, who they are, how they got there, and also how would you, if you had a court case, how could you possibly end up in the Supreme Court? Okay, so the videos that I want you guys to watch, either go back right now and watch them before we start, or after we're done, go back through, are going to be the one that is linked to the New York Times article. That is the one that says Supreme Court introductions on here. How do SCOTUS justices get appointed? That's the one that is in the middle, and it says, how do you United States Supreme Court justices get appointed? How a case gets to SCOTUS, so how do you get to the Supreme Court? That one is going to be the one on the bottom left, the Vox video. And the last one, the CNN inside SCOTUS, inside the Supreme Court, and that's going to be that bottom middle one, the CNN one. Okay, so the ones you need to watch: Supreme Court introductions, that's the green link, the TED Ed, the Vox, and the CNN. Okay, so let's start this. The judiciary. So the Supreme Court is usually referred to as the court of last resort. What that means is you can't go any further than that particular court. It is the end all of all law. Okay, whatever they say goes. Every other state has to follow it. It becomes basically the precedent from that point on. In the court, there are currently 9 Supreme Court justices. They're referred to as justices, not judges. They are judges, but they call them justices. There's a Chief Justice. His name is John Roberts, and then there are 8 Associate Justices. He gets paid a little bit more. I don't remember exactly how much, but he gets paid a little bit more. He has a few more little responsibilities he has to do. Now, remember the word jurisdiction. That is the types of cases that a court can hear. Like I said, traffic court will hear traffic issues. Divorce court hears divorce issues and things like that. Criminal court hears things concerning crimes. Well, the Supreme Court is going to have what's called appellate jurisdiction and original jurisdiction. So that means a case can actually start there, and a case can appeal its way up to the Supreme Court. So it's kind of interesting that it has jurisdiction over everything, basically. They hear court cases from the federal and the state court. So you can make your way from the bottom little bitty local court all the way up, keep appealing, keep appealing, keep appealing, keep appealing. Eventually you can make it to the Supreme Court if they want you, which we're going to talk about in a few minutes. Now, to be a Supreme Court justice, it's kind of weird. There are no requirements. And there's something, one of those videos actually talks about the fact that there are no requirements, and that's kind of strange that there are no requirements. No education requirement, no age requirement, no citizenship requirement. We have had non-citizens become Supreme Court justices. The Constitution doesn't specify anything on qualification. So it's kind of strange that somebody with so much power doesn't have any qualifications. They don't have to be a lawyer. They don't have to have been a judge before. They don't even have to have a high school diploma. Anybody can get picked. So here is our current Supreme Court. I want you to look at some of the people that are on there, look at who put them in, and look at, some of them are really old, some of them are not incredibly old. So you can see the first one on there, he's been there the longest. Ronald Reagan, who was president, he became president when I was 1 year old. John Kennedy is the person that was put in place by him. Now, he was put in place in 1988, and he has been there since, I said John Kennedy, Anthony Kennedy. He's been there since 1988, and he is still there. So he has been there the longest. He is not the oldest, though. Clarence Thomas was put in by George Bush. So Reagan, go back real quick, Reagan is a Republican. George Bush is a Republican. Clarence Thomas is interesting. He had some controversy when he was getting through the appointment process, because once you're appointed, you have to go through a congressional hearing. The Senate has to say okay to you. They have to give you the thumbs up. Well, he was accused of sexual harassment on the job previously. So there was a whole bunch of, stuff going on, kind of similar to what happened a couple years ago when we watched the Brett Kavanaugh case come out, and he was also accused of sexual misconduct and things like that. Ruth Bader Ginsburg. Now, she was put in place by a Democrat, Bill Clinton. She is the oldest, the cutest, the littlest, and the feistiest one on the entire Supreme Court. Well, I'll show you a picture in just a second. John Roberts was put in place by Bush. Now, he is rather young. He's not the youngest, but he is rather young, and he is the Chief Justice. So he's kind of the head guy. Now, George Bush, he is, again, this is George Bush, the second one, so W. Bush. He is a Republican as well. So far we have a Republican president putting in a justice, another Republican putting in for a justice, one Democrat, and then another Republican. Okay, so you can kind of see where things are leaning as far as politically. Sam Alito, he was put in place by George Bush as well. Sonia Sotomayor, she was put in place by Barack Obama. So there was another Democrat. Elena Kagan, also put in place by Barack Obama. Neil Gorsuch and Brett Kavanaugh are the newest, and they were both put in by Trump. So if you look at that, we have Republican, 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 Republican. That is a whole bunch of conservative-leaning justices, which we're going to talk about what that means eventually, about being conservative or liberal and how that plays in the court system. Okay, here's the guys that are in charge. This is the head of the judiciary, basically. We have on the top row, Neil Gorsuch, Sonia Sotomayor, Elena Kagan, and Brett Kavanaugh. The two on the ends of that top row, those are the two newest guys put in place by Trump. At the bottom, the oldest, the longest serving justice, Anthony Kennedy, Clarence Thomas, John Roberts, Ruth Bader Ginsburg, and Sam Alito. Ruth Bader Ginsburg, she is the oldest. She just turned 87 years old, actually, I think last weekend. And like I said, she's the tiniest, yet the feistiest on the entire court. So the way that the appointments work, it's kind of interesting. A president is going to appoint a justice only when there's a seat open. So you have to have a justice die, you have to have a justice retire, or you have to have a justice that goes through impeachment for you to have a spot open. So otherwise, you can't just say, I'm taking you out and I'm putting a new guy in. There has to be an open spot. So why is that so important to a president? And it comes down to the Supreme Court justices that a president puts in is their legacy. Like I said, Ronald Reagan, he still has a justice on the Supreme Court that he put in place in 1988. That's Anthony Kennedy. Reagan has been dead for many, many years. That is his legacy in our political system. So they carry out whatever the president who appointed them felt they would carry out for the good of the ideology, the party, or the beliefs. So a president's going to pick somebody that they think is going to be there and work in their best interests. It might be a Republican interest, it might be a conservative ideology, but they're putting people in there to last longer than they last as president. Okay, so why doesn't a president just appoint whoever, like their best buddy or something? And that comes down to the appointment process. You have to get confirmed by the Senate. If the Senate does not like you, does not want you, thinks that you are a bad fit, you will not get appointed. Okay, so your party, you got to work for your party. You always have to think about that politically. You have to choose somebody that your party members will like. And then he has to get the person confirmed. So you can't just choose anybody. The Senate has to give the thumbs up. So it's not just a cut and dry, I want that guy, we're done. It's, I want that guy. Do you like that guy? Will you approve that guy? And that's the end result, is what the Senate actually says. Okay, so here's how the Supreme Court works. It's a little bit confusing, but remember, the end result, the last place you can go, is the Supreme Court. So if we go all the way to the bottom of this little chart, you have U.S. district courts and state trial courts. That's how many cases they hear a year. 314,000 cases a year through the district courts. State trial courts, 101 million cases. That's insane. Now, some of those are going to appeal to try and make their way to a higher court because they don't like their decision that was made in their lower court. 52,000 cases go to the U.S. Court of Appeals out of those 314,000. And then 70,000 of that 101 million goes up to the state courts of last resort, which are going to be these state Supreme Courts, which if you've never seen our state Supreme Court, it's this ginormous white marble building in the middle of the French Quarter. You've probably seen it. You probably sat on the steps, but it doesn't really have a big prominent, sign or anything. Now, of those cases, of that 52,000 and 70,000, only about 80 to 90 cases ever even make it to the Supreme Court, sometimes even less than that. So it's kind of weird to think about. Not very many cases ever actually get to the Supreme Court. It's a hard process to get through. You have to have something very, very either controversial that can change the course of everything that goes on in the United States, something that is constitutional in nature. If it's not that, you're never going to make it to the Supreme Court. Okay, so the Chief Justice, some of his responsibilities, he is responsible for assigning judges to different committees. They have to be in charge of certain things. He has to respond to proposed legislation that affects the judiciary, and delivering the annual report on the state of the judiciary. So just like the president has the State of the Union, the Chief Justice has the state of the judiciary. He also gets to play a role during impeachment trials. That's something that we got to see this year. John Roberts was the presiding justice at the Senate hearings for impeachment. Now, if you look at the right-hand side, it says which cases reach the Supreme Court. Very, very few. You saw that, 80 to 90. So this is kind of the process that it has to go through. You can start state and local trial courts, appeal up, you go to the state courts of appeals. You appeal up, goes to the state Supreme Courts. Now, usually 90% of the things never actually make it out of that bottom piece. So it's just a handful that moves up. And then to get to the Supreme Court, you have to do something called a writ of certiorari, which we're going to talk about. It's a weird Latin word, but I'll get into that in a second. On the right-hand side of this chart, it says you can start in the U.S. District Court, the U.S. Circuit Court of Appeals, writ of certiorari, and then the Supreme Court. It doesn't usually happen. If you really want to get to the Supreme Court, you're probably not. Now, this is how to get on the docket of the Supreme Court. Now, the docket of the Supreme Court, it's just a list. I've talked about a docket before when we're talking about the docket for legislation. It's literally just the list of the court cases that come up. If you've ever been to the federal courthouse or even the lower courts in Baton Rouge, they will have a docket on hand that you can physically see and go, this case is next, this case is next, this case is next. That's all the word docket means. So if you want to try and get on the Supreme Court's list or docket of court cases they're going to hear, this is the process that you have to go through. Again, it can start in federal court, it can start in state court. Then you have to start this request process, okay? The request process is the writ of certiorari. What that means is it's a request to be heard. That's all it is. It's a please, will you listen to my case document. The request for the Supreme Court review, there's probably between 7,500, sometimes more, up to 8,000 requests. The justices are going to take all of these 7,500, not just the justices, they have a whole staff that works for each one of them, and they discuss it. They go through it and they're like, let's see, this week we're going to talk about this group, and they call it the discuss list. And they go through and they sit there and weed them out. Do we listen to this one? Is this a good one? Should we put it on the yes side or the no side? So they kind of pro and con them. 98% are going to be denied. So just a little bitty handful gets moved forward. And that's when they do what's called the rule of 4. Now, the rule of 4 is in your terms. It basically means 4 of the 9 judges have to say, yes, we need to listen to this case. That's kind of interesting because a lot of things that we do in our government has to do with majority or 2/3 or 3/4. In this case, we only need 4 judges through the rule of 4 to say, yes, I like this. Let's listen to this. This is a serious issue. We definitely need to hear it. And then of those, they get placed on the actual Supreme Court docket, which ends up being between 70, sometimes upwards of 100 cases for the entire year. And that's it. There are no more. Now, the interesting thing is they only have 1 hour for each case to actually be heard. So it's kind of interesting. They go through all of that process and they get an hour to discuss it. So back to that chart that I showed you guys, we're going to start at the bottom. Okay. So if 4 or more through the rule of 4 of the 9 justices decide in a vote to hear the case after receiving the records, this case is officially going to be put forward. Okay. Every Friday, it sounds kind of weird, but every Friday the justices meet together. They actually have a little lunch. They sit together in this big dining room and they talk about their discuss list. So these rule of 4 cases move up and they start discussing them. This is where the court decides to vote on whether or not to issue this writ of certiorari. What that means is they look at the petition, the writ, and they say yes or no to it. Okay, so that petition is very important. You have to be very convincing to get these people to say, yes, we're going to listen to this case. So the next piece that comes up is after reviewing these cert memos, these certioraries that they have now created, the clerks of court, these are going to be the people that work for each one of the justices. Each justice has a certain number of clerks that work for them. The Chief Justice is going to distribute the discuss list of possible cases. To get on the Supreme Court's docket, all justice clerks get to do the actual reading of the filed petitions, and one clerk will write what's called the cert memo, which is a description of everything in the case, all the legal arguments, all the files, all the facts of the case, and they share that memo with the justices. The Supreme Court is going to then have approximately 7,000 of these petitions. Okay, so if we go back to that little graphic that I showed you guys, where we're at about 7,500, I think, that they have to then figure out, what do we do with? Okay, so it's kind of interesting, that process. You start with this huge number of cases and then you weed it out. You weed it out, you weed it out. So 7,000 cases, the clerks listen, they get the cert memos, they then give it to the justices do the discuss list, they talk it over, they then look at it and say, we will accept the writ of certiorari or that petition, and then the rule of 4 comes in and they go 1, 2, 3, 4, like it, boom, it's going to be on the court docket. So now what they deal with is paperwork. This is not an attorney comes in and you go in and you have witnesses and stuff like that. Nope. It is a paperwork court. An attorney will go in. It's the attorney that will be representing you. And they don't really present their case. They're more there for questions to be answered. So every one of the justices is going to write up these questions, these ideas, these things that they want to know about the case. That's why the attorney is there. Everything else, the justices have read all of these paperworks, all of the arguments from previous courts, all of the lower court decisions. They know all that going in. So that's why you don't need to have court again. You don't have to have that, that trial or whatever again. You have your attorney there. You can be present, and you don't have to be present though. It's not like that kind of court where you're like subpoenaed and you have to be there. So you can go with your attorney, and then the attorney is there to basically explain what the constitutional issue is and why your case needs to be dealt with, and like the former decision needs to be overturned. A good example is going to be Obergefell versus Hodges. Okay, Obergefell versus Hodges is about the right of gay marriage, to marriage equality. And what's going to happen is in the state, they were not allowed to get married. They were told, you cannot in the state. I'm sorry. Well, they were like, wait a second. I'm a citizen of the United States. There's no reason I shouldn't be able to get married other than the fact that possibly the Christian culture that we have doesn't like it. So that's how that ended up in the Supreme Court. And they're going to use the 14th Amendment to say, yes, as a citizen, you do have the right to marry whomever you want, male or female. So once the Supreme Court grants this cert, or the certiorari, the case is added to the court's docket. Each side files what's called briefs. If you've ever heard of a legal briefing, that's what they're talking about. This basically says, this is my argument for my side. You can get briefs from other people. These kind of act as like your paperwork witnesses, and it's called amicus curiae. And that means friend of the court. So a lot of times the people that will be the friend of the court are going to be people or organizations that are there to fight for that person or that group's rights. So for instance, Obergefell versus Hodges probably had LGBTQ groups that were amicus curiae for their side. If we were going back to our snowy owl that was endangered when we were talking about the iron triangles, the Sierra Club could be an amicus curiae through that iron triangle process. So it just means friend of the court, and they will also submit things to try and help that side's case, basically. So interest groups are really good at doing this. They're kind of like professionals at being friends of the court or amicus curiae. Now, after reviewing these written briefs, the judges will hear the oral arguments. Now, this is where the justices can ask questions. So if you're a lawyer and you're going in and you're like, I got stuff to say about this, you might not have anything to say about this because they will stop you. They will say, nope, I have a question. So as soon as you're like going to present your case, they're like, I have a question about this. Okay. Oral arguments are 30 minutes. So I said 1 hour, each side gets 30 minutes. So Obergefell versus Hodges concerning marriage equality, Obergefell, their lawyer had 30 minutes. Hodges, their lawyer had 30 minutes. And that's questions, that's answers, that's presenting your case. And that's it. After that, they're nothing. So, you know how many times I've told you guys, let's go to oea.org and find out information about some of these cases that we've talked about. Well, if you go there, they have all of the oral arguments for every case. Each side has a half an hour. So when you click on it, it's only 1 hour of listening. There is no video in the Supreme Court. They don't allow any kind of video taking, any kind of cameras. None of that is allowed while the court is in session. So everything is just audio. That's all they've ever allowed, audio or actually, transcribing by writing. So after oral arguments, the justices are going to meet privately in their Friday conference. Remember, they hang out on Fridays and have lunch. That's where they vote on the case. And so say the case was dealt with on Monday. Monday was when it was presented, the 1 hour thing. They have until Friday to think it through, to decide, to write down, check their notes and stuff like that. So they have time to kind of consider things. Now, the next thing that's going to happen, if the Chief Justice is in the majority, so when they take this vote, basically, and the Chief Justice is in the majority, he's going to choose who's going to write what is called the opinion, okay? And you guys have seen that on OEA, I believe. If he is not in the majority, the longest serving justice in the majority gets to choose, okay? Any of the justices may write a dissenting opinion. So you have two big opinions that are going to happen. You have the concurring opinion or the majority opinion. So majority opinion is the person that is part of the majority that is going to write, this is what we think is correct. Okay, this is our decision. Then you can have a concurring opinion, which basically says, yes, I agree with you. And then you have the dissenting opinion. The dissenting opinion is the one that says, I think you're wrong, and here's why. The dissenting opinions are usually my favorite to read. I know that sounds super dorky, but they have a lot of information about why they disagree. And sometimes you're like, well, yeah, you're kind of right. There's some really cool dissenting opinions concerning the Westboro Baptist Church that I love reading. I had to do a big study on one this past summer. So anyway, the law clerks, remember each justice has their law clerks, play an important role in drafting these opinions. So a lot of times the justice is not writing everything down. They are basically telling their law clerks to scribe down what they want to have said. No opinion is considered final or binding until it is officially announced. So they literally have a set time where they go out and all of them present their opinions. It's posted online, supremecourt.gov, and published by the government in volumes called the U.S. Reports. Also at the website, you can see every possible Supreme Court case that has ever existed. OEA.org has, I think, almost all of them, but I'm not 100% sure if they have all of them. So deciding how to vote. There's some different ways that a justice can act. You have the legal model, the attitudinal model, and the strategic model. The legal model of deciding how to vote for, if you're one of these justices, is based on judicial decisions making that assume the judges will decide cases according to law. So meaning they look at the Constitution. The Constitution says this, done stamp. There's no wiggling around the words of the Constitution. The Constitution says this, period. That is the legal model of deciding a case when you are a Supreme Court justice. Then we have something called the attitudinal model. And that's decision making that assumes judges will decide a case according to their ideological preferences. So remember, if we go back to the list of justices and who appointed them, they all have a lean one way or the other. They lean conservative, they lean liberal, they lean Republican, they lean Democrat, because the people that put them in place because they assume they are going to uphold those ideological beliefs. And that would be an attitudinal model of how to decide how to vote on a case. And then you have the strategic model, decision making that assumes judges are rational actors who will strategically try to get as close to their preferences as possible by building winning coalitions. So that's kind of like working together with each other to win the majority. Now we're going to talk about different terms for legal model and attitudinal model when we talk I think the next time we have one of these, we'll talk about that. It's the different ways that a justice looks at the Constitution. Some of them look at the Constitution as a cut and dried document. The words are the words, we follow the words, period. In 1789, this is what they meant. In 2020, this is what they mean. Same thing, nothing changes. And then there are going to be justices that look at the words in the Constitution. They're like, well, they wrote this broad enough to where we can wiggle around it to fit societal needs. And that's going to be a big controversy within the court. Should they be able to do that? So when writing opinions, again, after we have our 30 minutes of one side, 30 minutes of another side, boom, we decide. Then they have to actually write their opinions, which is going to be the end of the court case. Majority opinion. It's the opinion agreed upon by the majority of the justices. So we have 9 justices. We need 5 for that simple majority. The concurring opinion, again, written by a justice or justices, sometimes they combine, who agree with the majority opinion. So they're like, you're right, and I'm going to make sure that you know why you're right. And then the dissenting opinion is that I don't agree. I do not agree with this, but the decision's made. I'm still going to give you my 2 cents though. So it's going to be written by justices who completely disagree with the majority opinion. Okay. So you remember cute little lady, Ruth Bader Ginsburg, Justice Ginsburg. She is referred to as the notorious RBG. And part of it is because she is known for being the dissenter. She is the one that is willing to be feisty and say, I do not agree with you, and here is why. Her dissenting opinions are usually really fun to read. But yeah, she's feisty, and she will tell you you're wrong, period. And here's why. So she's kind of a fun little lady to watch. They recently actually came out with a movie about her called RBG. And it's like a documentary. And there was another one last year, I can't remember the name of it, but it came out, it was in the theaters. On the basis of sex. And it was basically her struggles as a woman working in her profession, which was not an easy task back in, again, she's 87 now. So when she started her career, women really didn't have that kind of career. So it's actually it's a really good movie. So anyway, the majority opinion is going to become precedent. The majority opinion becomes law. It becomes, that's it. Everybody's got to follow it. Done. Okay. So whatever a state says, they're like, I'm not going to do, the state has to do whatever the Supreme Court says. That's why we, like, for instance, going back to Obergefell versus Hodges, every state had to go along with, now some states put up a fight, but every state had to follow that marriage equality exists. So now in every one of the 50 states, a man and a man can get married, a woman and a woman can get married based off of that one Supreme Court case. So if it was in a state constitution that it was not legal, that is no longer okay. You gotta have to scratch that little piece out of your state constitution. And the precedent now is marriage equality. Anyone can get married. So some examples that we're gonna hopefully talk about in coming days, weeks, however long this is going to happen. Roe versus Wade, which is concerning abortion, and Mapp versus Ohio, which that's concerning something called the exclusionary rule. Roe versus Wade is one of your required Supreme Court cases, so you're going to need to know that one. Mapp versus Ohio is pretty interesting as well. There's some other ones we're going to talk about. Those two are just good ones to discuss. Maybe we'll do that on one of our lives. So basically, you guys, that's it. That's the end of this particular lecture. It wasn't as awful as the last one, I think. So anyway, make sure you understand who can choose the Supreme Court. Make sure you can choose, who decides on the Supreme Court. Make sure you know how the Congress is involved in Supreme Court justices. Know your process of getting into the Supreme Court. Starting from the bottom, you have to appeal up. Make sure you remember that process where the thousands become the 7,500, become the 100 or so, and that's the end. You won't become part of a Supreme Court case if you were not chosen within that 100. Know that you have to have a petition called the writ of certiorari. You have to be chosen by way of the rule of 4. Understand what an amicus curiae is, which is the friend of the court. So you can have somebody that speaks for you. Remember, also all of these Supreme Court cases are paperwork cases. You only get 30 minutes for your side of the case. Everything else has been already dealt with in lower courts. All right. See you guys later.